Establishment and commitment of the Supreme Court of India. Establishment and commitment of the Supreme Court of India. Supreme Court of India shall be constituted with the Chief Justice and not more than 7 members of judge of the Supreme Court and appointed by the President and consultation with the judge from the Supreme Court and High Court. So judge shall be edify until the attain the age of 65 years. Removal of the judge may be under his hand and seal. President resigned to the office. Chief Justice of India cannot be consulted in case of appointment of judge other than Chief Justice. So he is citizen of India. He has the 5 year and 65 year, which is he has the at least 10 year advocate in the High Court and 1 5 year judge in the Supreme Court, and he is opinion of the President of India is a distinguished jurist. A person is qualified for the appointment of the judge of Supreme Court. A judge of the Supreme Court can only be removed by order of the President of the ground of proven misbehavior and insolvency. No person who has held office of the judge of Supreme Court until plead of any court of before the authority within the Constitution of India. So 125 is salary and allowances of the judges are the second schedule. And the appointment of the acting judge of when the office of the Chief Justice of India is vacant or unable to perform duty of the office, President any appointed judge of the purpose. Appointment of the judges. Ad hoc judge. Chief Justice of India can appoint judge and consent of the President and in consultation with the Chief Justice of High Court. Attendance and require the judge of sitting of the Supreme Court. So Chief Justice of India as the consent of President can require retired judge of Supreme Court and High Court. Supreme Court to be have a court of records and the act of the proceeding of the Supreme Court are permanently recorded. It has been the power of the imposition of the attempt. So original jurisdiction of the Supreme Court and the Supreme Court original jurisdiction are disputes between the Government of India and the other states, between the Government of India and any states, and between the two or more states. Article 311 is the exclusion proceeding of the Supreme Court. The Supreme Court has a jurisdiction regard to the question to the constitution validity of the central law. Appellate jurisdiction of the Supreme Court. Appeal of the High Court in certain cases. The court appeal the High Courts on the interpretation of the Constitution. Appellate jurisdiction of Supreme Court in the High Court is regard to the civil proceeding, and appeals are to be the Supreme Court judgment, decree or final under the civil proceeding of High Court. And this is the question of the general importance. So this is the High Court set question 10 to the decide by Supreme Court. Jurisdiction of the High Court is an appeal shall be Supreme Court of any judgment final under into the consultation of proceeding of High Courts. So this is the special leave of the Supreme Courts and judgment could be the judgment enter into the and review the judgment of the Supreme Court. So review petition is there, special leave petitions are there. Okay, and this is the appeal to the Supreme Court of judgment final unless the confirmed to the proclamation of the High Court. So this all about the Supreme Court. And now next is Comptroller and Auditor General of India. He is appointed by the President. Salary and allowances of the Comptroller and Auditor General is specified in second schedule. He to in the manner similar to the removal of the judge of the Supreme Court, the Comptroller and Auditor General is not eligible for further office under the government and retirement. After retirement, administration expenses of the office of Comptroller Auditor General charge upon Consolidated Fund of India. So duties, powers of Comptroller General of India is the Union. Comptroller Auditor General is within the accounts of Union, states and any other authority procedure by the Parliament. The accounts of the Union and the states are kept in the form and prescribed in the President as the CAG audit required. The reports of the CAG of the accounts of the Union and the submitted to the President's who has the balance to the floor. So this is the cake account state submitted in the governor, and this who is the legislature. Now next one is the Article 153. There shall be a governor for each state, and the same person can be appointed as a governor to or more states. Executive power of governor and the executive power of the states is in the governor. Appointment of governor. Governor of the states appointed by the president. Term of office. The governor holds the during the pleasure of the president, and the governor may resign his office addressing to the resignation to the president. Governor shall hold office for the term of 5 years of date on which enters upon the office until his successor enter upon regardless the expiration of the term. So qualifications for the appointment of governor: a person eligible appointment of governor if a citizen of India and complete the age of the 35 year. Consolidate governor office. Governor shall not be a member of the other house of parliament, member of the house of legislature of new state. He must vacate his seats in the house before entering upon office of governor. Governor shall not hold any office of profit. Governor is entitled to emolument allowances privilege sacrificed by second schedule. The emolument allowances do not diminish during his term of office. President may discharge the function of the governor during the contingency. Power of governor to the grants pardon, and the governor states have power to grant pardon, reprieve, despite, and the remission of punishment. He suspend, remits, and commit the sentence of the person. Next is the 163. Council of the Ministry aid and advice to the governor. Council of Ministry with the chief minister is the head and aid and advice to the governor on the exercise of the function. Validity of the governor act under the discretion power cannot be questioned. Advice tendered by the ministry to the governor cannot be inquired into any court. So other provisions are: chief minister is appointed by the governor. Other minister appointed by the governor on the advice of the chief minister. Minister holds office during the pleasure of the governor, and the total member of the minister in the states cannot exist 50% of the total percent of the assembly. Number of ministry including the chief minister in the state shall not be less than twice. Council of Ministers collectively responsible to the legislative assembly of the state. If the minister is not a member of the legislative of the states for any special consecutive months, cease to be a minister, and the salary allowances of the minister as per in the second schedule. Next is appointment and the other conditions of the advocate general. So governor of each state appoint a person advocate general. Advocate general should be qualified to be appointed judge of high courts, and the duty of advocate in to advise the governor on the legal matters, to perform the legal duties referred to the resigned to the governor. Advocate general hold office during the pleasure of the governor, and the advocate general receive remuneration governor may determine. Conduct of the business of the government of states. All executive actions of government of the states are taken in the name of the governor. Order and other instrument made on the executive name of governor cannot be questioned. Duties of the chief minister: furnishing the information of the governor. It is duty of the chief minister to communicate to the governor all the decision of administration affect the states, all the matter of legislation. Governor advised to the required minister to submit the decision to any matter which is yet to better constitute to the council. So chief minister is the governor called to furnish information related to administrative affair and to furnish the information regarding to the procedure of the legislation. State legislation. So constitution of legislation is governor, legislative assembly, and a legislative council. Abolition and creation of legislative council of the states. Resolution has to be passed majority of total membership of the assembly, and majority of not less than 2/3 of the member of assembly present and voting. Composition of the legislative assembly is the legislative assembly of the states consist not more than 500 members and not less than 60 members of the direct election. State divide into territorial constituency, maintain the ratio between the population and the member of the seats. Territorial constituency shall be readjusted after the completion of census. Until the first census taken to state seats may be registered by 1901 census, and territorial constituency may be readjusted on the 2001 census. Composition of legislative council. Total number of the member of legislative council shall not be 1/3 of member of and shall not be less than 40. So 1/3 of the elected of the electoral constituent may be municipality, district courts, and the other authority. 1/12 will be the graduate of the university. 1/12 will be electorate consisting the teacher, two as and secondary, and 1/3 of election member of legislative assembly of the states. Members of the legislative assembly are not eligible for the membership in the council, and general governor. The remaining people in fields of science, literature, cooperative movement, social science, and art The duration of the state's legislation, the Legislative Assembly can dissolve, and the Legislative Assembly to term is 5 year. Date of the first meeting. Duration may be extended to Parliament by the end case of emergency. Parliament will extend this period not exceeding 1 year in a time and cannot extend beyond the 6 months after the proclamation. Duration of the Legislative Council. The Legislative Council shall not be subject to dissolution. 1/3 of the member of the retired to the every second year. So, qualification of the member of the state legislative: he is a citizen of India. He is, in the case of the seats legislative council, not less than 30 of this case, and in case of the seats in the legislative assembly, not less than 25 of the year. He possesses the qualification or may described we have under the any of the means by the parliament. So, governor shall summon the each of the legislation time of the thing fit. Time between the last sitting and the first session of the first sitting of the session should not be exceed 6 months. Prorogue the House, dissolve the Assembly. Governor address both the House of Legislative Assembly together. Governor address joins Assembly of the Legislative on the commencement of the first session of the each House and first session of each general election. Right of the Ministry to advise the Advocate General respect to House. Ministry of Advocate General right to speak in the they can take in the proceeding any joint sitting and other House, any committee legislation being member. So the Advocate General is not entitled to the vote. Next is Legislative Assembly shall choose a Speaker and Deputy Speaker. So vacational resignation, removal from the office of Speaker, Deputy Speaker shall vacate his office if ceased to be a member of Legislative Assembly. May be any time right under his seal address if the member of the Speaker to the Deputy Speaker. If such member of the Deputy Speaker to the Speaker, so may be removed from his office. Resolution in the Assembly passed by majority all of the members in the Assembly. So whether the Legislative Assembly is dissolved, the Speaker shall vacate his office until immediate before the next is starting. So the power of Deputy Speaker or the other person perform the duties of the persons on the Speaker. While the office of the Speaker is vacant, Deputy Speaker will act as the Speaker. Governor may appoint another person for the purpose of the Deputy Speaker. The Speaker is the Deputy Speakers cannot be preside while the resolution for the removal from the office under consideration. The Speaker shall all take part in the proceeding and he is entitled to vote only in the first stand, not in case of the equality of the votes. Legislation of the council shall be Speaker and Deputy Speaker. So vacation of the resignation and removed from his office, Chairman and Deputy Chairman shall vacate his office. It may be ceased to be a member of Legislative Council. It in such a chairman and a deputy chairman. If such a member is the deputy chairman resigned to the office, may be the removal from the office of resolution by the passed by the majority of the two members of the council. So deputy chairman acts as a chairman. Governor can appoint another person for the purpose in absence of the deputy chairman. Chairman and deputy chairmen cannot be preside while resolution of the removal of the under consideration. The chairman shall part of the proceedings and entitled to the vote only in the first instance, not in the casting vote. Article 198 is all the qualification of the sitting of the House shall be determined by the majority of the votes of member present and voting. The chairman and speaker or the person acting such shall not be voted in first and can only exercise casting one case of equality of vote. Other House of Legislature have the power to act irrespective of the vacancy in membership. Quorum to the constitute meeting of the House is 1/10 of the total member present and members of the House and 10th members of the House, whichever is greater. So total 1/10 and the 10 members. So the chairperson, speaker person acting in such can be adjourn the House or suspend the meeting until there is a quorum. Next is vacancy of the seat. No person shall be member of both the House of Legislation or Legislative of two or more states. So a seats become vacant if the member resign from writing under the hands and under the chairman of the speaker. The member is absent in 60 days of with the House. So disqualification for the membership. A member of the other House of the state shall be disqualified if the holds office of the profit and it's a unsound mine and stain for declare the competent. It's a undischarged insolvent and is not citizenship of India, has voluntarily acquired the citizenship of any other states and it's under any knowledge allegiance of the authority. So it is disqualified under the 10th schedule. So decision of the question as a disqualification of member under the 191 refer to the decision of the governor, and its decision is final. Governor shall obtain the opinion of the election commission, and accordingly penalty for the sittings and voting before the making the affirmation after article 188 is not qualified and disqualified, the penalty of the 500 rupees for the recovered in the debt of the states. Next one is the article 196 is the provision for the introduction of passing a bill. A bill may originate in either house of legislation state which is legislation council. A bill may legislature of the state shall not lapse by the reason prorogation of the house. A bill pending in the legislative council of the state which not been passed by the legislative assembly shall not lapse on dissolution of the house. A bill pending in the passed by the legislative assembly of the states but pending in the council shall lapse on the dissolution of the assembly. Restriction a bill of the passed by the assembly of the states but pending in the council shall lapse. And restriction on the power of legislative council to be the bill other than money bill. A bill passed by the legislative assembly of the states transmitted legislative council reject the bill 3 months else without the bill is passed in the bill his amendment to which is the legislative assembly does not act. So legislative assembly may pass the bill again in same or in an subsequent session without any amendments. So the legislative assembly then transmit the bill to the passed to the legislative council. If after bill is passed by second time the legislative assembly is transmitted to the legislative council and legislative council the bill is rejected more than 1 month exclave without the bill is being passed and bill is passed with amendment to which the legislative assembly does not agree. So the bill is demand to be passed by the house of legislature of the states with the without amendment. Special procedure is respect to money bill. A money bill shall not be introduced in legislative council. Legislative council will within a period of 14 days return the bill to the legislative assembly with its reconsideration. Legislative assembly may accept reject all the any of the recommendation of legislative council. The legislative council does not return the bill to the assembly within the 14 days. It may be deemed to have been passed by both the houses. Next is provision of the introduction of the bill. Next one is the assent of the bill. Any bill passed by the legislative of the state is sent to the governor to assent. Assent to the bill is first tense or return to the bill if it's not a money bill or reserve the bill for the consideration of the president. So return the governor can be passed by the house without amendments. As a pass is presented to the governor for assent, the governor shall withhold assent therefore, or governor shall reserve the bill for considering president if become the derogates power of the high court. So bill reserved for the consideration. When a bill is reserved by the governor for the president shall assent the bill or direct the governor to reaffirm the bill to the house, and the return will in the reconsideration or house within the 6 months. And if the bill is again passed by the house without amendment, it shall proceed again to the president for his consideration. Every financial year, the governor lay the annual financial statement to the legislative. Annual financial estimates of the expenditure constitute expenditure of charge upon consolidated fund of India, expenditure charge upon the consolidated fund of India met by them. So the expenditure charge upon consolidated fund of India's emolument allowance of the governor, salary of the allowance, debt charge of governor, salary allowances, pension of judge and high court, some are required to satisfy judgment, decree and awards. The chairman and the deputy chairman of the legal and the speaker and the deputy speaker of legislative assembly. So the procedure in the legislative with respect to the estimates expenditure charge upon the consolidated fund of India shall not be submitted to the vote on legislative assembly, shall be discussed by the legislative assembly. Other expenditure charge consolidated fund of India under the submitted to the form of demand for the grants in legislative assembly. So House of the People power to assent or refuse on assent to any demands, to assent to any demand subject to reduction and specified no demand for the grant shall be made except the recommendation of the governor. Appropriation bill is introduced in the appointment of fund from the consolidated fund of India. Appropriation bill can be amended to vary their destinations. So to vary the amount any expenditure charge upon consolidated fund of India. Supplementary, additional and excess grants the governor shall lay before the legislative assembly and other statements of excess grant, vote on accords and vote on credit and exceptional grants, and legislative assembly have the power to make the grants in advance and to make the grants for the under withhold demands under this, and this is make the exceptional grant which is form part of the current service of the financial year. Article 208 Rule of Procedures. Each House of Legislative states can make rules and conduct of the business. Each house of business in the parliament shall be transcript official language and Hindi and English. Any member who cannot adequately express himself in Hindi English can address the House in the mother tongue. Restriction on the dissolution of the legislative states. No discussion takes place legislative states regarding conduct of the judge and high court. So courts not be inquired into the proceeding of the legislation. The validity of proceeding on leg cannot be questions on the ground irregularity of the procedures. No office of the member of the legislature shall be subjected to the jurisdiction of any court. So legislature cannot be questioned on ground of irregularity of the proceeding. Power of the governor promulgate to the ordinance. So the both the House of Legislature is not in session. Governor may promulgate ordinance some following circumstances. An ordinance promulgated under this article shall have the same force of effect of the legislative states sentenced by the governor, must be laid before the legislative states and cease to operate. Expiration 6 weeks from the reassembly to the legislative assembly. Cease to operate if before the expiration of period resolution disappear. It's passed by legislative assembly and may be withheld at time of the governor. 214 is the shall be a high court of the state. High court is the court of records and has the all power to the imprison person to the contempt. Chief justice and the judge of the high courts are appointed by president. So in case of the appointment of chief justice, a president consult the chief justice of India and the governor of states. In case of appointment of the judge other than chief justice, president consult the chief justice and high court. Judge can hold the office until they attain the age of the 62 year. A person is qualified appointment as a judge of the high court if he is a citizen of India, has for at least year hold the judicial office in territory of India, has for at least 10 years for the advocate of high court, and he is the opinion president distinguished juries. So permanent judge of the high court can be plead only in the Supreme Court and other than high courts. Transfer of judges from the high court to the another. President consult the chief justice of India to transfer the judges from the high court. An appointment of the action of the chief justice. Acting judge is the appointment of the president to perform the functions of the chief justice. The power of the high court issue certain writs to habeas corpus mandamus, prohibition cure warrant on certiorari. High court can power to the issue order writ to any of the authority any government within those territory. Writ jurisdiction has been in the Supreme Court. Power of the superintendence over the court or high court. High court has superintendence over all courts and tribunals throughout the territory of the jurisdiction. High court may call for return to the courts and make the general rules and prescribe from the regulations. So high court do not have the superintendence over any courts and tribunals, but extension of jurisdiction of the high court in union territory, and the parliament may by extent execute the jurisdiction of high court to union territory. Next is appointment of district judges. District judges are appointed by the governor of the states in consultation with high court. Eligibility practice for the 7 year of the advocate and are recommended by the high court as for the appointment. Administrative Union Territory. Union Territory are the administrative president throughout the administration. Administration are appointed president with such a designation. It has to be may specify. President may appoint the governor as a state administrator of the adjoining Union Territory. 243A is the Gram Sabha. So the powers and function of Gram Sabha are determined by the legislative of states. Constitutional and panchayats is village level, intermediate and district level. There shall be a constitution of every state panchayat. Composition of panchayat is the reservation for the seat, the scheduled caste and scheduled tribe, and the 1/3 of seats for the women and 1/3 of seats for reserved for the women for SC/ST, and office of the chairperson of the panchayat are reserved for ST/ST women. 1/3 of total member of the office of the chairperson in the panchayat are reserved for the women. Duration of panchayat is the 5 year, and the amendment of any does not cause dissolution of panchayat at any level. Disqualification for the membership. A person is not eligible to member of panchayat if he is attained to the age of 21 years, which disqualified on under the made of legislative states. Powers, authority of responsibility. So this is legislative. State may by law dissolve power of responsibility upon the panchayat. With the power of the panchayat can prepare plans for the economic development, social justice, implement a scheme for the economic and social justice. Power of impose the tax to the funds to the panchayat. Authority of the panchayat levy, collect appropriate taxes and the toll fees, and the assign to the panchayat tax duties and tolls fees and collected to the state government. Provide the asking the grant in aid in the panchayats from the consolidated fund of states. Provide a consolidated fund creating the all money received respectively. And the Constitution of Finance Commission review the financial governor of states of the expiry 5 year. Constitute a finance commission to review the financial matter of panchayat. Audit of the account of the panchayat. So election of the panchayat. Election to the panchayats are conducted state election commission. Conditions of the service of the tenure of the office of the state election commission determined by the governor. State election commission can only be removed from manner of the similar removed judge of the high court. Gram Sabha, power of the function of the Gram Sabha determined by the legislative state's constitution, panchayat village intermediate level, and the composition of panchayat, reservation of the seats for the women and SC/ST. Now, the power duration of panchayat is a 5 year. Disqualification of members not attain the age of 25 when and disqualified on the legislative of the states. Prepare plans for the economic development, implement the schemes. Authority of the panchayat levy, collect, appropriate the tax of toll, assign panchayat to tax duty toll fee for collected by state government. Provide the making grant in aid to the panchayat consolidated fund of India, and provide the constitute funds for the crediting all money receiving respectively by the behalf of the panchayat. And the Constitution Finance Commission to review the 5 year. Constitute Finance Commission for review the financial matter. Election of panchayat. Election to be the panchayat is constitute the election commission, and this is the state election commission, and for the manner similar to the high court and judge. Qualification of the municipality. So they shall be constituted in the Nagar Panchayat, Municipal Council and Municipal Corporation. Composition will be the seats of municipality filled through the direct elections from territorial constituency. Municipal areas divided into the territorial constituency known the wards. Member of the represents by the state legislative municipal include the person having the special knowledge in the experience of municipal administration, right to vote, and the member of the House of the People and the member of the Legislative Assembly of the States, the member of the Council of States and the member of Legislative Council. So there is the constitution of the composition of the wards committee. Ward committee are constituted to the territorial area of the municipal having population of 3 lakh and more. Reservation of the seats of the reserved for the scheduled castes and the scheduled tribes, and 1/3 of total reserved seats will be for the women, and the 1/3 of the total filled with the every municipality shall be reserved for the women. One office of the chairperson in the municipality reserved for the scheduled caste and scheduled tribe and women. Duration of municipality is the 5 year, and no amendment any can be affect the causing dissolution of municipality. Disqualification the power, authority of responsibility, and legislation of the states may law and no power authority enable them to function institutional self-government. Legislative states reserve power responsibility upon the municipality. So prepare the plan of the economic development and the social justice, perform the functions of the implement the 12 schedules. Okay, so power of the impose the tax by the fund by the municipality. Legislative the state by law. Authority municipality levy, collect, appropriate the tax duty and fee. Assign to municipality tax toll and the levy to collect the state government. Provide for taking the grant in aids in the municipality from the consolidated fund of states. Finance commission and the adult audit of the accounts of the municipality. Administration of the scheduled area and the tribal area. So provision for the 5th schedule doesn't apply to the states Assam, Meghalaya, Tripura, Mizoram, and the provision of 6th schedule apply to the administration of tribal area of the Assam, Meghalaya, Tripura and Mizoram. So shall not it does not apply in the Assam, Meghalaya, Tripura, Mizoram, that is 5th schedule, and that will apply in the 6th schedule. Extend to the law made by the Parliament and the legislative state. Parliament may make law for the whole of any territory of India. Legislative of the states make law for the whole of territory of the states. No law made by Parliament shall be deemed to be invalid on the ground of it would extraterritorial operation. Subject matter of the law made by Parliament and the legislative states. Parliament exclusively power make law in the Union list of 7th schedule. Legislative of the states have exclusive power to make the law for the state list. Parliament, legislative of the states have power to make law in concurrent list. Power of the parliament to provide the establishment of certain additional courts. Parliament by law provides the establishment of the additional courts. So restrictive power of legislation. Parliament has the exclusive power of making law for imposing a tax not mentioned in the concurrent list and state list. So power of parliament to legislate with respect to matter in the state list in national interest, and if the necessary of the expedient national interest, the parliament make law with respect to the matter enumerated in the state list. Council of States has the declared of the resolutions supported by not less than two-thirds of the members present and voting to enact the law in the state list. Such resolution remain in the force for a period of not exceeding 1 year. Power of parliament to state list of the proclamation of the emergency in the operation. A law made by the parliament during the proclamation of emergency is to be expiration of the period of 6 months after proclamation. Legislation for the giving the effects of international agreement. Parliament has the power to make any law for the implementing agreement convention for this, and the consistency between the made by parliament and law made by legislation. So law made by the legislation of the states is deemed to be void if the repugnant is the law made by the parliament. Obligation of the state to the union. The executive power of the state shall be conceived compliance with the law made by the parliament. Control of the union over the states. Certain case, executive power of the union shall extend to the give direction to the states, not impede to the prejudice the exercise of the executive of the power of union to construction of maintenance of the means of communication in the direction national military, and to take the measure to the protection of the railway. So the power of the union cover the power of the states. Certain cases, president may with the consent of the governor of the states concerned function of the state relation any matter which is executive power of the union. So power of the state to entrust the function of the union. Governor of the states may with the consent of the governor of India entrant function of the relation to the matter which execute the power of the state extend use the water, distribution of water, control the water. So the parliament may by law provide the adjudication dispute with respect to neither the Supreme Court nor any other exercise jurisdiction respect to any interstate water dispute. Provision with respect to the interstate council. President order of the established interstate council. So inquire into the advice upon the dispute among the states and investigate the discuss subject to the common interest, and making recommendation on subjects for the better coordination of the policy. No tax shall be levied or collected except the authority of the law. Consolidated Fund and the Public Account of India and the states. So Consolidated Fund of India comprise all revenue received by the Government of India, all loans received by the government of issue by the treasury bill, loans, way and means, advance money received by the government in payments of the loans. So Consolidated Fund of India is all revenue received by the government of states, all loans raised by the government by issue by the treasury bill, and loans, way and means, advance of the money received by the government of the repayments of loan. All the other money, public money by on behalf of the Government of India and the Government of States belong to the Public Account of India. Public Accounts Contingency Fund of India established in the Parliament and established a meet to the unforeseen expenditure pending for the by the Parliament under the Article 1115. It established the meet the unforeseen expenditure, and Contingency Fund of India plays a dispute of precedent. So Contingency Fund of India states legislative. This may be a law established by Contingency Fund. Contingency Fund of States is placed disposal of the governor of the dates. Establish the meet unforeseen expenditure pending authorized to the legislature states for this. Now, the duties levied by the union but collected by the appropriation of the states. Stamp duty of the such duty, excise, medical and toilets expenditures are union but collected appropriated by the state. Service tax levied by the union and collected appropriated by the union states. Tax levies by the collected union but assigned to the states. Tax on the sales of purchase of the goods. Tax on the consignment of the goods. So tax on the levy distributed between union and state. All the tax duty of the union except the duty of the tax in the article 268 and 269. Surcharge tax duty under the 271. Any and the levied specific purpose under the law made by Parliament. Distribution of the prescribed President and per recommendation of the Finance Commission surcharge on the certain duty and the tax purpose of the union. So Parliament may by any increase any of the duty of the tax surcharge. So all proceeds of the surcharge added to the Consolidated Fund of India. Grants in lieu is duty of the dues and procedure. Prior to recommendation, President required to bill affecting taxation in which states is interested. Grant from the union to the states. Grant in the age charge for Consolidated Fund of India. Parliament by law determine the different sum of different states tax profession trade calling employment exemption property union of state taxation. The property of the union are exempted from the all tax imposed by the states. No law of the state shall impose on the authority of the impose the tax. So exemptions from the electricity and shall be imposed authority imposition tax for the electricity, exemption of property for the states and union territory. The property and the income state shall be exempt union taxation. So this all about the tax matters. Now next is 280. At the every fifth year, President has the order to constitute a Finance Commission. So Finance Commission is the constitute the chairman and the four other member of the commissions are the distribution of the net proceed of the between union and states to principle of the governing the grantee net to the states of the Consolidated Fund of India. The measure needed to be assignment Consolidated Fund of India and the supplement to the source the panchayat. The measure needed to be augment Consolidated Fund of states to supplement the source to municipality. Any other matter referred to the Commission, President and interest of the finance. So the recommendation of the Finance Commission is the advisory. President shall curse every recommendation made by Finance Commission to lead each house of the Parliament. President lay the recommendation together with the explanatory memorandum of the action taken. 292. Borrowing of the Government of India. Union has the executive power to borrow upon the security of Consolidated Fund of India. Limits and guarantee was fixed by the Parliament and the borrowing of the states. States may executive power to borrow from the territory in the security of Consolidated Fund of India and the limits of the guarantee fixed the legislature by the states. Trade and international throughout the territory of the India. So powers of the Parliament impose restriction on the trade and commerce, and this Parliament may by impose the restriction on the trade, commerce and interstate trades, and the restriction of the legislative power to the state with regard to the trade in the commerce. Parliament by legislation shall be the power to make the law for the discrimination on the states in list of this 7th schedule, and Parliament have the law to the scarcity of the goods in any part of the territory and the restriction of the trade commerce in, and this legislation of the states may by law by the goods imposed from the states and under the 7th schedule on this all our legislation state without the prevention any proceeding of the this all about the trade. Now Article 315. Public Service Commission for the Union and States. There shall be a Public Service Commission for the Union and Public Service Commission for the states. 2 or more states may agree together to join a joint Public Service Commission. Public Service Commission for the Union, if request to do so, the Governor of the states may, with the approved by the Presidents, give serves all the any of the needs of the states. So Public Service Commission for the Union is requested an appointment of the term of the office member, the chairman and the member of the Union and joint Public Service Commission appointed by the Presidents, the chairman and the other member of the State Public Service Commission appointed by the Governor of the states. If the office of the chairman becomes vacant, his duty performed by one of the other member of the commissions. Tenure will the 6-year terms or will be the 65 year and until the age of the 65 and 6-year term, and the which is the attain the 62 year in the states. Okay, 60 years from the date, 6 year from the date which is the enter upon the office, 6 year from the date upon enter upon the office, and until the age of the 65 and the 6 year until the age of the 62 year. Okay. Now next is the member upon the joint commission resigned to the writing to the president, a member of the state commission resigned to the writing governor, member of the public service commission removed from the office the manner provided by the clause 3(1), and the member of the public service commission are not eligible to reappointment after the expiration of the term. Removal of the member of the public service commission, chairman of any other member of the Public Service Commission shall only be removed on the order of the President inquired to the Supreme Court. Suspension of the member of the Public Service Commission and the chairman any other member of the commissions may be suspended in the proceedings in case of the Union commissions and Joint Commission by the Governor. Case of the State Commission, President has to pass order to receive reports to the Supreme Court to suspend member of the Commission. President may by order remove the chairman or any other member of the Public Service Commission is adjudged insolvent, engage in the office of profits and opinion of President unfit for the continue in the office of reason for infirmity of minds. So function of the Public Commission is to continue examination for the appointment of union and state, to assist the states for the recruitment of candidate, to advise the matter so refer to the proceedings. So this Union and State Public Service Commission has consulted on the all matters regarding to the method recruitment of civil servants and the making the appointments and the promotion of civil servants, the transfer candidate from one service to ability to such appointments, promotion and transfer on the principle of the followed in on the all disciplinary matter and the on all claim of the awards of pension. So expense of Public Service Commission are charged upon the Consolidated Fund of India and the expense of states on the States Consolidated Fund of India. Reports of Public Service Commission is the submit to the reports work done by the Commission to the President. So President lay down reports Parliament. A State Joint Commission annually submits reports to work done of Commission to the Governor, and the Governor of the states lay down the reports and the state with the recommendation. So this is the Public Service Commission. Now next one is the Administrative Tribunal. So the Administrative Tribunals are law adjudicate, it try to dispute relate to the recruitment and the condition of the Public Service Commission. Article empower the established Administrative Tribunal Union and for the states. So the tribunal for the other matters, tribunal may be established following matters: levy, assessment, collection, enforcement of tax, for foreign exchange, imports, export, across the custom duty, industrial labor dispute, land reforms, ceilings and the property, elections and other matters of the Parliament, production, procurement, supply of distribution of the food disturbs, rent, regulation, control of the tenancy issue. Next one is 320, Superintendent Direction, Control of the Elections. So Parliament, Legislative of the States and Office of the Presidents, Vice President, Composition of Election Commission, Chief Election Commission and the other Election Commission, any of the Presidents. So appointments, all appointments are made the behalf of the Parliament of the Presidents. President may also appoint the reason for commissioner and consult with the election commissioner. So the service of the election commission and the regulation of the commissioner determined by the President's. Chief Election Commission can only be removed manner similar to the removal of judge of the Supreme Court. Any other elections of regional commissioner shall removed only by the recommendation of the Chief Election Commission. No person shall be ineligible for inclusion or claim of include special electoral roll, a group of the region of the race, election of the House of the People and the Legislative Assembly of the state to be on the habit of the adult suffrage. Every person who is the citizen of India and not less than 18 year age is the entitled to registration vote. So grounds of disqualification: non-residence, unsound mind, crime, corrupt and the illegal practice. So power of the Parliament to make a provision for the respect to the election of legislation, preparing the electoral law, delimitation of constitution, all other matters for the necessary ensure the Consolidated Fund of India. Power of legislature of the state to make the provision with respect to the election of legislature, bar to interference by the court in the electoral matter and any other law relating to the delimitation of the constitution or the allotment of shields should not be called on the question on a court, and no election of either House of Parliament, either House of Legislative of the state shall be called on question except election of the petitions. Next one is the Article 338. So there shall be a commission scheduled caste known the National Commission for Scheduled Caste, chairperson, vice chairperson and 3 members. So condition of the service of the tenure of the officer determined by the President by rule. Chairperson and vice chairperson of the member of the commission appointed by the President to investigate upon all matters, safeguard the provided scheduled caste, to inquire into the specific complaints for the respect to deprivation of the right of safeguard of scheduled caste, to participate in the planning process of the socio-economic development, to annually submit the reports of the working of the scheduled caste, and to make the recommendation take union and states effective in implementation of safeguards, and to discharge the welfare and the developmental and the advancement of the scheduled caste. So this is the President laid the report to the Parliament, and this any report forward to the Governor if state government is concerned with the issue. National Commission for Scheduled Tribe. There shall be a commission to the scheduled tribe known the National Commission for Scheduled Tribe. Chairperson, vice chairperson, and three member. Condition of the service of the tenure will be the determine the precedents by rule. Chairperson, vice chairperson, and other member commissions appointed by the presidents. So commission has the power to regulate, to investigate, the monitor the regulation of the safeguard of the scheduled caste, socio-economic development of the scheduled caste, and the advancement welfare scheme for the development of scheduled caste process of the to working for the safeguarding the powers of the scheduled caste. The president lay down the report to the parliament and the forwarded to the governor if states government concerned with this. C43 is the official language of the Union. Official language of the Union Hindi and Devanagari, and form the numbers of official purpose. International forms of Indian numeral. Official language of the states and the legislature of the states may by law adopt any one of more of the language in use of the states Hindi and official language until the legislation of the states otherwise provided by the law. The English language shall continue to be useful for official purpose. So official language of the communication between the states and another between states and union. Special provision is relating to the official spoken, the selection of the population of the states. Language to be used in the Supreme Courts and the High Courts. All the proceedings will be in the High Court will be in the English language. Okay. And this is the governor with the consent of presidents authorize the Hindi is any language of the High Court having a participate with that. So there will be the Hindi, English, and the mother tongue. C52 is the proclamation of the emergency. President any proclaim emergency satisfied that the grave situation is arise for the security of the India is threatened by the war, external aggression, and the armed rebellion. So the proclamation under this article is commenced term the national emergency. President may declare emergency in respect of the whole of India or any part of the territory or made specified by the proclamation. So proclamation of emergency may be varied or revoked by the subsequent proclamation. President cannot be issue or vary proclamation unless Union Cabinet suggests proclamation to him is writing. So proclamation cease to operate at the expiration of 1 month unless before the expiration of the period it's has been approved by the resolution of both the House of Parliament. Proclamation shall cease operate at the expiration of the 30 days from the date on which House of People first sits for the recommendation. So dissolution of the House of the People take place during the periods of 1 month, and the proclamation issues the time when the House of the People have been dissolved. Resolution approved by the proclamation has been passed by the Council of States but not passed by the House of People. So the proclamation is valid for the 6 months from the date of passing the seconds of this resolution from the proclamation. If resolution approved by the continuation for the such as proclamation is passed by both the House of Parliament, proclamation shall be continued to the further power. So this is the resolution by the passed by the either House of Parliament only majority of total membership of the House and by the majority of not less than the 2/3 of the member of the House present and voting. So special sitting of the House held to the 1/10 of the total member of the House of the People will be the resolution disapproving the proclamation. So resolution has been given the call to the House of the Sessions and the not so provide if the House is not in the session. So the special sitting of the House shall be held with the 14 days from the receipt of such in the Speaker or President. Proceeding of the emergency and fundamental emergency of this. So this is the power of the Union shall be the discretion of the states, and the Parliament make the laws respect to the matter of the Union list. So emergency provision shall be extended to the states under the state which proclamation emergencies operations. So this is all about the proclamation and the appointment of the provision relating to determining the while proclamation of emergency. So it is a duty of the Union to protect the states against the external aggression and internal disturbance. So provision in case of failure of the constitutional machinery of the state is 356. Presidents are received to report the governor and any proclaim so satisfied that the governor of the states cannot carry down in accordance with the procedure of the constitution. So the presidents may proclaim about this power. So president cannot be assumed himself any of the power vested exacerbated by the high courts. President cannot be suspend whole of the part of the operation any provision of this constitution relating to the high court. but proclamation shall be operate expiry of the 30 days and at which house of people are after the reconsideration. So dissolution of the house of the people take place during the period of 2 months, then proclamation is issued with the house with people has been dissolved. So the resolution approved by the proclamation has been passed by the Council of States but passed by the House of People. So proclamation valid month will be the passing through the second of the resolution appear to the proclamation. So note shall be removed from the 3 years. So resolution is procedure shall be here for not passed by their house. So this page is blur. I will discuss again. Next is part 61. So protection of precedence in the governor. President or the governor is not answerable to any court for the exercise any performance of power of duty and office. Conduct of president may be brought under the review of the courts tribunal of the body